I do not accept this offer to contract, and I do not consent to these proceedings.
Everybody put on your tinfoil hats.
Yeah, so you may remember that everybody's favorite sovereign citizen, Edward Thomas Kennedy, has filed a bunch of stuff recently. So our ears are perked and our nose is to the grindstone when it comes to the sovereign citizen stuff. So it was with a lot of glee and a little bit of hysteria that when we found out that there was a letter in one of the R. Kelly accusations. Now, this is from October of last year. We only found out about this now. It hasn't really been a major headline or something. But then again, it's R. Kelly, and if you've heard about some of the things he's accused of, he's a scumbag. So he has been accused of some things then, and he was accused of some things now. And he was apparently served with some court papers in, it looks like, the Faith Rogers accusation. And this is his response to the lawyer for that party. Dear Ms. Hills, Esquire, the attorney, this is to enlighten you concerning the presumption of court appearances that you may not be aware of, since attorneys are taught a coloring of law and not canon or common law. Color of law is not law, it's fiction for corporate fictions, of which I am not.
Very strong opening.
Very strong opening.
Yeah.
I'm unaware of what coloring of law I have been taught, other than to say when we're in law school, we learn law more generally than it is in, say, any one specific state. Even for example, the state that you study in. So I studied in Pennsylvania for the Pennsylvania bar, and there still wasn't a heavy emphasis on state law. There was a little bit of an emphasis on state law, definitely more emphasis on Pennsylvania state law than other state law, but there was more of an emphasis on here's how law generally works. Now when you go study for the bar, you will learn the relevant state law for your bar that you're studying for. But I'm not aware of what he means by canon law. I think canon is a synonym for something, not a different kind of law, but rather just another way of saying, the law of something is the canon of something. I'm not really sure.
If I Google it, canon law is ecclesiastical law, so it's in reference to the Catholic Church.
Okay, so church law would be canon law. Got it. So one, we don't follow church law in the U.S. We do follow common law, and attorneys are taught common law. In fact, we're sometimes taught more common law than we really need to know, because while you do make common law claims when you assert claims generally in everyday lawsuits, there's usually also a statutory law, a codified or written law that is much more comprehensive and usually plays out a little bit easier. It depends. We are taught common law and we are taught statutory law. We are not taught canon law. That's correct. It's fiction for corporate fictions, of which I am not. Well, that's the first part that tells me it's a sovereign citizen thing. We're starting to talk about who's a fictitious person and who's not. Although I do get the confusion of what happens, what corporate entities and what the corporate personhood and all that thing is, especially after Citizens United. It's a little weird to have this whole corporate personhood thing, but that's not what we're talking about as far as when it comes to personal responsibility when you're responding to legal documents. So then I'm guessing if you're saying canon is a ecclesiastical law, then he's talking about some kind of ecclesiastical presumption of summons here. Canon 3228V or 5, the presumption of summons. A summons when unrebutted stands as truth in commerce. Attendance in a court is usually invoked by invitation, and therefore one who attends court initiated by a summons, warrant, subpoena, or replevin bond is presumed to accept the position of a defendant, juror, witness, or thing, and the jurisdiction of the court. Those were in parentheses for some reason. And a replevin bond would be a bond to recover something, money or a thing, I think.
Yeah. Replevin is you want the thing back. So they stole your car, you want your car back. That's replevin, as opposed to money.
And so the bond would be the document that says you're entitled to it back. And so, you go, what happens is, because who thinks about this? So let's say that you want your thing back. You go to the people who stole your thing and it's sitting on their property. Do you just pick it up and walk away with it? What if they come out and try and get it? What if they call the police and say, no, that's my thing? So you have a bond, you have a piece of paper signed by a judge or something, equally persuasive that says, this is my thing, and I'm not the one that's in trouble. He's the one that's in trouble. But I have no idea what the hell he's talking about with this whole truth in commerce. A summons when unrebutted stands as truth in commerce. I don't even know what that means. I think he's saying that a summons is optional, and if you choose to not respond to a summons, then you don't consent to the court's jurisdiction then.
Uh-huh.
If these instruments are not rejected and returned, with a copy of the rejection filed clearly on the public record, the presumed position and the presumption of guilt also stands as truth in commerce. What does he mean by commerce? Is he talking about the Commerce Clause of the U.S. Constitution?
I'm assuming that's exactly what he means. He's thinking some sort of interstate commerce. Yeah, that's exactly what he means.
This is how we get jurisdiction on things. No, the Commerce Clause is about states and federal rights. Where is the line drawn between a state's ability to regulate commerce within the state and how much commerce the federal government is allowed to regulate? And so the Commerce Clause of the U.S. Constitution, and there's also this inverse called the Dormant Commerce Clause, which says that well, I'll go over both in one sentence. The government gets to regulate and not regulate anything within interstate commerce. So this means they can regulate cigarettes because they travel in between states. They can regulate the internet because it travels in between states. They can regulate guns because they travel in between states. They can regulate lots and lots of things as long as they just go in between states. That's it. So, for example, if you thought, well, marijuana should be a states' rights thing, well, yeah, except that it also touches interstate commerce because supplies have to be bought and people come from all over and all that. So the federal government has said, it's what about 80 years ago this started, that, anything that just touches interstate commerce, even just a little bit, that we can just argue, has anything whatsoever to do with interstate commerce, we can regulate it 100%.
Yeah. Grumble, grumble, Wickard v. Filburn. Grumble, grumble.
That sounds like it has massive implications. I mean,
it changed the power of the federal government. It changed the balance of power between the states and the federal government forever. For the past 80 years. We don't even know, like we have almost no cultural concept of what life would have been like under more states rule back then. We can look at history, of course, but we don't feel it today. We don't go, oh, so great that we switched from states' rights to federal government rights in regulating interstate commerce. It doesn't work like that. If these instruments are not returned or rejected, the presumption of guilt stands as truth in commerce. So he needs to reject the things. The answer, response, reply to the subpoena is now rebutted by notarized 16-word statement across the face of the summons, refusing the invitation, which states, I do not accept this offer to contract, and I do not consent to these proceedings, and filed with the state's attorneys and the clerk of the court, placing it on the public record.
It has to be on the public record.
If he doesn't have to consent, and if it's so not applicable to him and everything, but then I've got to follow other court processes and procedures. It's such a picky choosy thing. Just go pay your damn attorney. What the hell? How does this man not have enough money to pay his attorney to do this for him?
I love how he thinks that the courts are like, hey, you got to show up, you got to participate in this. We have jurisdiction over you. If it's a criminal offense, we could go to jail. And he thinks that he can nullify all of that by clicking "Do not accept" on the terms of service.
Yeah.
It sounds like he took way too big of a rip before writing this. Do you know what I mean? Like,
Write drunk, edit sober. You got to remember the second step. It's Hemingway, right?
I've done some of my best work at a bar, but still, this is.
Oh yeah. No, it's a good idea to loosen up a little bit. You just gotta leave time to proofread it when you're sober. You know, and these are analogies. I'm not encouraging people to go get severely intoxicated to create, but you know, there is a in between. There's a little bit of a buzz or a little bit of an experience. Please advise Ms. Rogers, your client, to abandon this heartless effort to try to destroy my musical legacy for selfish personal enrichment. If she persists in court action, she will be subjected to public opinion during the discovery process. For example, my law team is prepared to request the production of the medical test results proving the origin of her STD claim, as well as 10 personal male witnesses testifying under oath about her sex life in support of her claim, and complete records of her text/FaceTime message exchanges, which will be reviewed to match and be authenticated by the recipient to ensure that there are no omissions or deletions.
He's uncomfortably close to a blackmail problem.
Yeah, this is very close to blackmail. First of all, when you have discovery of information of this level of personal whatever nature, it's often protected. One, there's a basic level of confidentiality through the litigation privilege that things that are designated so are basically confidential between the parties until needing to be disclosed publicly as part of the pre-trial and trial process. But then you can also get stronger protection orders, and we often go to court for these protection orders, asking the court to protect someone's identity or protect certain information while we're in the middle of discovery and preparing our case. And then that information only comes out when it's been properly vetted and is considered relevant and necessary. And even then, sometimes certain personal information or salacious things don't come out that don't need to. Courts have standing orders to not disclose things like birth dates and social security numbers and home addresses in criminal cases or non-criminal. I think it's non-criminal cases, something like that. So it finishes here. If Ms. Rogers really cares about her own reputation, she should cease her participation and association with the organizers of this negative campaign. Counteractions are in the developmental stages and due to be released soon. Yeah, he like Kurt said, this is really close to some kind of witness tampering or blackmail or extortion or something, because you can't threaten a witness in a case. You really can't even attempt to influence them, right, Kurt?
Pretty much.
You really can't even say, by the way, I disagree with what you said you're going to testify about. You shouldn't testify. That's obstruction. That's obstruction. That's over the line. You can bring your own witness. And if he has this law team, which I've never heard of anyone call it a law team, but okay.
No, I kind of like it though. Maybe we should call ourselves a law team.
Yeah, I mean, I'm not saying the guy can't use words. He is supposed to be an R&B artist though, right? That does involve words. But if he has a law team, why didn't he just have them write this? That's just weird. So this goes on. This is not the end of it. He writes a page called Testimony. I, Robert Sylvester Kelly, an Illinoisan of Chicago, Illinois State.
I like the Illinoisan. That's a nice touch.
An Illinoisan.
That is not the word. As somebody from Illinois, I'm pretty sure it's Illinoisian and not Illinoisan. That's the weirdest thing I've ever heard.
Make oath and say / hereby affirm that 1, I do not accept this offer to contract, and I do not consent to these proceedings. Okay, let's kill this now. This is not contract. When you get a summons in the mail, that's not a contract. The summons is part of your process, is part of your due process. The process or procedure that is due to you under the law. that allows you to have a meaningful interaction with the court system and have your rights fairly adjudicated by an unbiased court of law in a timely fashion. Now, some of that's loose. Timely means a year in many cases. Being bonded from jail is usually 3 days, which is an awful lot if you're innocent or otherwise prepared to bond out. So contract law just simply does not apply to receiving a summons in a court order. Let's continue, though. I am exempt and not subject to this court, so I don't know why you are even addressing me, or why you continue to address me when I do not accept this offer to contract and I do not consent to these proceedings. I am a flesh and blood, living, breathing American national and native of Illinois. Private agreement is mutually agreed upon and entered into on the 14th day of the 9th month of the year of our source, 2017, between the juristic person, Robert Sylvester Kelly, copyright, also known by, and all derivatives and variations in the spelling of said name except Robert Sylvester Kelly, hereafter jointly and severally debtor, and the living, breathing flesh and blood man known by the distinctive appellation Robert Sylvester Kelly, copyright, hereinafter creditor.
Okay, I have so many questions.
He's loaning himself money?
There's 2 more paragraphs like this.
Year
Robert
of our
Sylvester
source
Kelly
is the
in this
first. I've never seen that
private
before.
In this private agreement, the term Robert Sylvester Kelly means Robert Sylvester Kelly copyright, and any and all derivatives and variations in the spelling of said name except Robert Sylvester Kelly common law copyright symbol, 1985, Robert Sylvester Kelly copyright, all rights reserved. What?
I'm concerned for this man's health.
Okay, so what it looks like, maybe he did a copy paste and then changed some words around, but I wasn't aware that there was a debtor or a creditor. I wasn't aware that you could copyright your name or names in general.
Wow. Okay.
Because trademark, I could understand. If he wants to say my trademark is R. Kelly, okay.
Oh, yeah, sure. Yeah, my
But-
trademark, I perform under the name R. Kelly, and this is my trademark, and you can't use it, and all of my content is copyrighted. That's fine. But that has nothing to do with the court case about what I'm guessing this is about. Since I am not voluntarily involved in any of this, and never conscionably was, and since my assets have been or are being dragged into this mess without my knowledge or consent, and since all the other parties that secretively are benefiting or benefited themselves at my expense are now trying to palm this situation off on me, and since this court works for those same parties and is acting in gross conflict of interest and under color of law, any issue related to this complaint that continues to involve me or affect my assets in any way is going to be settled by private binding arbitration, and I am going to choose the arbiter. Now that you've made your offer and I've made mine, it is time for all of you to give me some answers. By, I'm assuming this is Robert Kelly, and then there's some kind of witness here. The funny part is the witness line doesn't say who the witness is, so we know who is supposed to be signing the undersigned line, the by line, that would be R. Kelly, but then who's the witness? It doesn't say. It does have this little weird paragraph here. Autograph, common law, copyright 1985, Robert Sylvester Kelly, all rights reserved. No part of this, or no par of this autograph, common law, copyright may be used nor reproduced in any manner without prior express written consent or acknowledgement. Oops, I guess we shouldn't be talking about it, guys. He said we can't. Without prior express written consent or acknowledgement as signified by his signature in red ink. Unauthorized use of Robert Sylvester Kelly incurs same unauthorized use fees as those associated with his copyright name as set forth in paragraph 1 under self-executing contract security agreement in event of unauthorized use. Enclosure, published copyright notice. What?
Is he really threatening to go after people for unauthorized use?
Yes, sue us, R. Kelly. Sue us for talking about your strange court filing here.
Oh, the irony.
So now he files this notice of delivery I, June Barrett, declare that I caused the foregoing notice of delivery to the clerk of the court, including these attachments. I do not accept this offer to contract, and I do not consent to these proceedings on the face of the summons and verified complaint and demand for jury trial, living testimony in the form of an affidavit, and Anne Faith Rogers pictures and text messages to be served upon the persons listed below by having a copy of said notice of delivery and attachments electronically delivered to the Supreme Court of the State of New York, etc. And then he writes on top of the complaint, the summons, I do not accept this offer to contract and I do not consent to these proceedings. Is that a stamp? Does he have like a giant stamp? That he just
I want that stamp.
Can we make a T-shirt that
Yeah,
says
I
that?
want to order it.
we need to make a T-shirt that says that, and we need to order a giant stamp that says that with a giant stamp pad. And then the same thing on the notice of appearance, you are hereby summoned to appear. He says the same thing. There is a notary public named June Barrett who had to witness this for him. That's funny.
June Barrett probably didn't actually read any of it, which is for her own benefit.
The notary is just a witness of the signature. So this is not, the notary didn't sign off on any of this. The notary is just literally a professionally licensed witness for court purposes and other purposes. When you go to have a will signed and things like that, depending on the circumstances, this is not legal advice when to use a notary, but sometimes when you have to have an official witness for something, you go to a notary who then just makes sure that they check your identity, they check the other party's identity, they see the two of you sign it. You often don't want to sign the document until you get to the notary, so you can sign it in front of the notary, and then the notary stamps it and makes their own signature that says they saw the signatures and verified it. And then when you go to court over this document later, you don't have a second level of dispute over whether the document was actually signed by the parties or not. Because look, it was witnessed by a notary. We can either just ask the notary, or why even challenge it? Because look, it was witnessed by a notary. So that's why he's doing this thing with the notary. Now, can we get some follow up on this? I'm assuming this did not work for him. Okay, and the reason that this is in the news now is it looks like it is being released now. This letter was released on or about January 15th, it looks like.
Which probably means that the lawsuit was adjudicated pretty recently, right?
And it looks like Robert Kelly's lawyer, Steve Greenberg, has denied the letter's authenticity, says it was obviously not authored or signed by Mr. Kelly nor sent on his behalf. He doesn't write the letters. So yeah, this could be entirely fake. If so, that's an awfully interesting thing to fake.
Well, and the fact that it's notarized would be weird too.
Well, let's find out. Is there a June Barrett notary? June A. Barrett notary does not come up.
Dun, dun, dun.
Dun, dun, dun. Yeah, I don't find a June A. Barrett notary on Google. I mean, I'm not saying it's not possible, but I'm not finding that at all.
Yeah, I mean, I was a notary for a while, and I didn't exactly advertise it, so it's possible that you can be a notary. And
yeah, but wouldn't it show up on some kind of rolls? Like if I search for Kurt Mueller attorney, you're going to show up on some kind of roll.
Yeah, I don't know. Well, back in the day, at least, and I don't know if this is still true, it was in a physical book. Yeah, so I don't know if it's listed online now. That was back in '99, so yeah.
Yeah, like so I searched for a notary near me that I know someone's name, and she came up in at least 3 different places right away.
Wasn't there an identification number near her signature?
Probably.
Possibly. Let's take a look.
When it gave her location?
What is this weird zip code thing?
Which one?
June Barrett, Illinois State, CF 60623.
60623 is a Chicago.
Yeah, but CF 60623, CF?
I don't know what CF is.
And
I wouldn't know
whoever
what-
says Chicago, Illinois State.
Is that what it says? Oh, Chicago, comma, Illinois State. It is weird, but
Yeah, so the proper way to abbreviate it is Chicago, comma, capital ILL. I'm not saying that, you can't do it differently, but who writes Illinois State?
I bet it's another sovereign citizen thing. He's trying to make a point about Illinois being a state and like not part of the federal government or something is what I'm betting that means.
So sovereign citizen June Barrett as well?
No,
Or
I'm suspecting that R. Kelly or whoever wrote this
he prepared
this
this and then just had her.
Yeah, so I'm suspecting
sign it.
Barrett did not prepare this page.
Okay, and let's just compare. Let's do a few things. Compare her signatures on the various pages. Her signatures don't match. You guys seeing this?
They do look different.
I make
They look very different.
the first whip of my L for my name always looks almost exactly the same, and hers looks different each time.
LBX Annie says that when they did a search for CF60623CF, the only result was this PDF.
Yeah.
Interesting.
So this could very well be fake. It is a decent fake if it is fake, and it certainly smacks of sovereign citizen stuff. It could also be that someone did send this and then just more or less, later on their lawyer denied it. Because really, what's the consequence of that anyway? If my client sent something like this, I might tell the opposing side to ignore it and apologize for my client speaking out of turn, and then if it got public, to tell the world, this didn't come from my client. This is a fake. It certainly sounds like a real thing that could have happened, because this is what sovereign citizens do, or what that type of behavior leads to. It's always fun to read one of these things and see the latest thing that they've come up with. And I don't mean they collectively. I just mean someone who denies the jurisdiction of the system. And this is a very basic misunderstanding, by the way. Like, I'm not trying to get too down on or raise myself up as high and mighty above people who misunderstand the law. Actually, I think I have a lot of empathy for that. I'm not saying you need to agree with me that I have a lot of empathy. I feel like I have a lot of space in my heart for the forgive them, they know not what they do position. The law is confusing. No one really explains to you in school what a social contract is, how that works, let alone that it's not really a contract. It's more of like a guideline that's enforced with your life. Either obey the social contract or face the consequences of not obeying the social contract. It could be getting locked up, could be being exiled socially, could be worse than that. So I understand how someone could get through American high school and not understand what the basic sources of law are. But this is just next level nuts.
Okay, so I found her.
Yeah, I found for the notary public search, June Barrett from Chicago. I found a commission number, but it says that she's inactive.
Yeah, that's possible. It does on this say that her commission expires 2020. My commission expires November 15th, 2020. So how could she be inactive unless she actively made herself inactive? And this document, what are the dates? October 29th, 2018. So if she signed this just a few months ago, someone may have used June Barrett's services and then used her seal and replicated her signature or a signature.
Several different signatures apparently too.
Well, it could be. I mean, I'm not saying it couldn't be that her signature, the slant is different on, the T's are different on those two.
This is where I get nervous because my signatures
this
don't look the same.
Yeah, this looks to me like someone has potentially forged these signatures. I'm not accusing anyone, but jeez, that's someone who's approximating someone else's signature. Let's look at the October 29th as well.
I mean, my signatures never look the same, so.
Yeah, but certain parts will. The way you do certain loops or the slant that you choose. A signature often has an attitude about it. And if you read the signature like you would read a person's attitude, it is often about 85% correct. So if a person is writing in very small font, like too small for the line that they're writing on, you can sort of assume that person might lack confidence. If a person's slant is way too far to one side, you could again infer that they are feeling somewhat off. If a person's signature is way too large for the thing, they may be feeling weak and may be overcompensating. If a person's signature looks shaky, they may literally be nervous, et cetera, et cetera, et cetera.
I am missing one step.
Yeah.
It's how would a third party who would forge this know of the original summons in order to forge the letter? I mean, they'd have to know about it.
Wouldn't the summons be on the docket though? Wouldn't when the complaining party requests the summons, isn't a copy of the summons put on the docket?
I don't know how Illinois does business.
So it's possible that it was served, and maybe even the return of service was in there, and they just edited the pages of the documents out or other things.
In the one civil case I was in, yes, the summons was added to the docket.
So,
but who is this third person that would profit from forging the letter?
Someone who has hate for R&B.
But why would they go the /sit / leaning towards
Could
witness
already
tampering?
be crazy.
That was mostly a joke on my part.
so the speculation here is an incredibly obsessed fan wrote this for some reason. Is the possibility? I mean, I guess it's possible.
Yeah. Here we go. So New York State CEF. EF is usually electronic filing. New York Supreme Court would be NYSC, and Supreme Court of New York is the lowest court in New York. It is a court of first opinion, or let me see if I've learned a word from Edward Thomas Kennedy, a Nisi Prius court. So this has been printed from the CEF system, we call it a CMECF system in federal, so I'm getting that mixed up. This has been printed from the EF system. Now that might be the way it's done, but it might also be that someone printed this off of the system and then sent this in. Second, look when this would have been sent. This summons would have been from May 21st, 20-something in the tens. So I'm assuming that's 2018. Why then is the summons being returned with this notarized letter and everything in October? So maybe it is fake?
Have you looked at R. Kelly's signature, Matt? Matt asked me privately on Discord if you've looked to see if it looks the same and all that.
Yeah,
because you were looking at the notary, but
R. Kelly signature. Yeah, I'm not seeing a lot of copies of his signature. Let's try autograph. Doesn't really look... Well, some of these look positively fake. But compare that with that. I'm not seeing anything that's even remotely similar about the way he makes those autographs.
How about the air signatures on the page of his? Are they even consistent with themselves?
Yes. But also not really. So there's the spike up at the top, and there's this thing here. This comes down here. Also, the witness. Wouldn't the witness have been the notary? I guess not. I guess that's why we had to make this second notice of delivery here.
Yeah, not necessarily.
Even the signatures for his autograph or whatever, they seem to be a little bit different. The signer seems to have signed it 4 times, but they don't seem at all consistent. And then let's look at the Lydia Hills for comparison, because this would have been from... the summons would have been signed by Lydia Hills, Esquire, Faith Rogers' attorney, and they look, frankly, nearly identical. Almost every part of them looks absolutely identical. Certainly not exactly the same. So, yeah, I think this might be either a hastily created letter or a terribly done fake. Convincingly, certainly convinced us for a little bit that it could be a letter from R. Kelly. So I think we still edit this together and put this out with a giant question mark on it.
Yeah.
Are you
Yeah, do you
basically
wanna-
telling me that this was too good to be true? It was too good.
It might actually be too good to be true.
Should I put that as the opener then? I think that this might be a convincing fake.
Well, maybe.
And then you go.
You figure it out when you're editing it, but I think the title should be something like R. Kelly, sovereign citizen, question mark.
Okay, one more thing while I'm thinking about it. If this were a fake letter, presumably because it's in the electronic system, R. Kelly's lawyers would have become aware of it. So wouldn't they have filed something on the docket saying that this previous letter is a fake formally?
The summons would have been on the docket, and yeah, I'm assuming that they would have had, if he's saying in the letter, I need to put this thing on the docket officially, yeah, there should be something on the docket officially.
Yeah, I'm just wondering if this case came to R. Kelly's lawyer's attention if he was summoned, which I'm assuming the answer to that question is yes, one way or the other. And if it came to their attention, and if it's fake, you would think that they would put something on the docket saying this prior letter is a fake. So I'm wondering if they actually filed anything officially in court saying that.
Let's take a look. New York Supreme Court e-filing.
Because if they said it on the record, I'll take it as true.
Account. Search as a guest. Enter the characters. JRBVTR. I am not a robot. And what's the case number here? Case number is got to be listed here someplace, right? It is not listed here? Let's see. Name. Party. Last name. Kelly. Robert. Robert E? No, Robert. County. New York County. So Faith Rogers, Robert Kelly, 5/21/2018. So that's the proper date. Yeah, there's nothing on the docket. It shows... Hang on, I'll try to fix this. There we go. It shows the summons, a complaint, an affidavit of service from 10/4. So he was served on 10/4. So it is entirely possible that he sent something on October 29th, because he wasn't even served until October. That timing is this gets weirder, right? It just gets weirder because the timing's now correct there for him to receive the summons right before he would have prepared and sent this. And who would have had a copy of this? Well, really, I mean, I guess anybody who goes on this website and downloads it. But would someone really have been watching to see when is he going to get served, and then I'll send a letter and screw everything up? It's possible. It's possible. However, it does not. I do not see anything on here that looks like it has been this rejection of this summons. You know, I do not accept your offer to contract or whatever. I don't see anything on here that suggests that this has been filed on here on the court docket. Everything that's been filed has been filed by Lydia Hills, who is Ms. Rogers' attorney. It looks like...
But this document has a e-filing number at the top of the printout, doesn't it?
Yes, this document is ECF1, the summons. So here we go, ECF1, the summons.
Okay, that's
and then
fair.
Down here, document number 2 is a complaint, and then it doesn't go on from there.
Is there anything in 4 or 5 that's helpful?
Preliminary conference request or request for preliminary conference.
Yeah, I wonder if there's anything in any of that might provide any light on this.
The undersigned requests a preliminary conference.
In terms of the letter that has the I do not consent to this, was that given to the lawyer or was that given to the courts?
That might have been given to the lawyer. It says though that he wanted to file this. It says here right in the beginning that these instruments must be rejected and returned with a copy of the rejection filed clearly on the public record. Wait,
so it says pro se. That's real encouraging. What's the other document?
Yeah, so then it says pro se. So wait, does he have an attorney who is then in this article back here saying that, oh, his attorneys have said that that letter is not genuine? Okay, well, why aren't you entering your appearance here, defendant pro se Robert Kelly? Like, where is his attorney? That's weird.
Yeah, look at the last document, the last filing where that's the response to whatever. See
this
if that
is
has
a request
anything.
for judicial intervention.
Yeah, let's see what that says. Nothing of help.
Nothing of help. So she's filing a request for a preliminary conference. They have an affidavit of service here, which looks like this. That she served him with the summons on September 14th. And so the weird part then becomes, why is there not like a notice of default or something? Maybe they're still talking, but why he hasn't responded on the public record? I'm guessing that there's something going on behind the scenes there.
Something's weird.
But so far, none of this flips my belief one way or the other that this is either a fake letter or not a fake letter. If it was fake, and he really did have attorneys that were responding, he wouldn't be pro se. As of January 8th was when we saw that say pro se, right? So, yeah, something's going on here. Either he hasn't secured an attorney until now, that could be possible. The letter could be fake, or it could be real and he just hasn't secured an attorney till now, because the summons was generated on May 21st and was served on him in September and returned on the 8th of October or something, and then he writes this thing back or allegedly writes this thing back on October 29th and then sends. So it could happen this way. I can't say one way or the other. You make your decision for yourself, my lawful masses. So what do we think of R. Kelly's? Do we think that's fake? Do we think that's real? And what do we think? If it's fake, that's an awfully compelling fake. And if it's real, that's absolutely nuts, right?
I mean, the lawyer that received it felt that it was real-ish, real enough to deal with it.
Do we know that the lawyer released it? Was that what the thing said? Or was it leaked to entertainment news sources? The Independent is reporting that the woman, who I'm guessing is Faith Rogers, because it says it in the next paragraph then, said that he had written to her in what she said was an attempt at victim shaming. The letter allegedly sent to Ms. Rogers said if she continued with her lawsuit, she would be subjected to public opinion. Lawyers for Kelly have claimed the letter is not genuine.
I remember that in that document.
Yeah.
That was a thing that was
that
said.
Doesn't
yeah.
change. It doesn't really change the evaluation, because even if it's released by the victim, that doesn't mean that it was sent by Mr. Kelly. And it does make sense that a person who is represented by attorneys would go through their attorneys in the vast majority of cases, which is why this is remarkable. If he skipped his attorneys and wrote this letter, this could also just be someone made a letter, which is also staggeringly scary, right? If some third party wrote a letter to the victim on behalf of a perpetrator without the perpetrator's knowledge. So if someone wrote this to Ms. Rogers on behalf of R. Kelly without R. Kelly's knowledge, holy crap. Like, as F. Scott Fitzgerald once wrote, this story is true whether or not it really happened. All right, so that's our show. Thank you very much for joining me. I am Leonard French, your favorite copyright attorney, here as usual to discuss the law with my lawful masses. We still use patreon.com/ljfrench as our primary method of financial support. The numbers came in from last year, and Patreon has a very clear win in the revenue stream. YouTube wasn't even close to the amount of money that Patreon generated. So congratulations, Patreon supporters. You've beaten YouTube, and we're making these videos for you. Now, I've been making videos for my Patreon supporters for the past year plus, as opposed to making videos trying to accomplish YouTube views. And the point is because Patreon supporters are the main audience. They're the ones who are supporting the thing and want to see the thing the most. And so we prioritize our content for the supporters. So the supporters have a channel on my Discord, as well as access, of course, to the Patreon private stuff, which we don't release too much patron-only stuff. If you guys want to see more of that, let me know. We'll try to come up with something. It's not like I can show you my day-to-day, because a lot of what I do is confidential with clients and things, but we can try to come up with some things. So for the month of January, our Patreon supporters are as follows. At the $50 level, thank you to Jonathan Doe, John Steele, Gavin Barnard, Evie, Andy, Kyle Mudrock, Vera Montaigne, Michael Pierce, Terry Crisp, Richard Fournier, Spirit Bear, Jan Negray, Daniel Perez, and Sean McNamara. And the $5 plus supporters, there are about 200 of you, are scrolling on the LED panel behind me and on the crawl of the video when Brandon edits them down. So thank you very much for joining me. Do I prefer Twitch subs or Patreon? I think Patreon takes less money. I think Twitch takes a higher percentage. What I haven't figured out is how to put Twitch subs into the Patreon. Like, I mean, obviously I can figure out how to do it. We haven't set up the system to do it yet. So if the Twitch supporters want to be in the list of sponsors, let me know. We'll figure out a way to make that work. And I'm assuming we're going to have a sponsus.org support page here at some point as well. And so all of that will have to get integrated. So there will be other support options as well, from Sponsus, from either PayPal or Twitch, and of course through Patreon. And YouTube, conspicuously, has not turned on our paid subscriptions feature on YouTube, even though it's only supposed to be a 30,000 subscriber threshold, and we're at 100. So I don't know what's going on there. Anyway, so thank you all for joining me. I'm Leonard French, your favorite copyright attorney, and I will see you in the videos that drop. Love you all. Bye. Okay. Pennsylvania in January is cold. I just smacked him with the ball. I smacked my poor puppy with the ball.